Zoe Coutts, Scott O'Connor, you have each been convicted of offences that resulted in the death of Kol Page. He died in 2024 as a result of injuries sustained in 2022 when he was 2 years old. You, Zoe Coutts, were Kol's mother. You've been convicted of causing or allowing his death. You, Scott O'Connor, were in a relationship with Zoe Coutts. You have been convicted of his manslaughter. You were each acquitted of murder. Each of you continues to deny responsibility. Each blames the other. Neither of you has shown any remorse. I sentence you on the basis of the jury's verdicts and the facts about which I am sure. Zoe Coutts, you are now 35 and of previous good character. You have 4 children. Kol was your youngest. He's been described as full of energy, boisterous, affectionate, and adoring you, his mother, and his siblings. You'd been in a long-term relationship from your early teens. You said it was an abusive relationship, and I sentence you on that basis, but without making any finding which is adverse to your ex-partner. You came out of that relationship in 2021. You then lived with your mother and other relatives in a house that was overcrowded. You took advantage of your mother's hospitality and of your sister, leaving them to babysit your children more often and for longer than they had reasonably bargained for. But you were a loving mother, and you did not mistreat your children. To the extent that there was occasional bruising to one or other child, that was accidental. In late 2021, you began a relationship with Scott O'Connor. You moved into accommodation provided to you by a domestic abuse charity in March of 2022. In breach of the rules, you allowed Scott O'Connor to stay with you there. You were advised to undertake a Clare's Law check. Had you done so, you may have learned of a possible history of domestic violence. You chose not to. There were then increasing incidents of Kol sustaining non-accidental bruising to his face of increasing severity. I'm sure that you did not inflict those injuries. You have no history of directly causing harm to your children. The jury found that Scott O'Connor inflicted the fatal injury. He was present when all of the other non-accidental injuries were inflicted. That included bruising to Kol's face on the 9th of April 2022, which was rightly described by an expert witness and other witnesses as horrific. You gave an account of that bruising which was untrue. You must have known that the injuries were inflicted by Scott O'Connor. Instead of taking Kol to receive the medical attention that he so obviously needed, you went to watch a football match with Scott O'Connor. Instead of protecting Kol from Scott O'Connor, you continued to live with him and to leave Kol in his care. Instead of telling others what was going on, you told lies about the injuries. Your failure to act and your repeated dishonesty about the causes of injuries to Kol exposed him to escalating violence and ultimately to the fatal assault. During the night of the 24th to 25th of April 2022, Kol was violently assaulted by Scott O'Connor, likely by a stamp or kick or punch to the abdomen. The assault was delivered with the force that is consistent with a serious road traffic accident or a fall from height. The force was sufficient to cause tears to his mesentery that envelops the small bowel. That resulted in a persistent and ultimately catastrophic bleed. By just after 9:30 in the morning, Kol had lost consciousness. When paramedics arrived, there was no pulse. Due to the application of advanced life support techniques, a pulse was restored, but only after half an hour. By that point, Kol had sustained severe and irreversible brain damage. If the clinicians had been aware of the history of abuse and therefore what was likely to have caused the injury, the medical response may have been different. Scott O'Connor, you are 36. You have previous convictions, including for battery in 2023, which was in the context of a domestic relationship. You've also been involved in other incidents of violence towards your father. The jury found that you were responsible for inflicting the injury that resulted in Kol's death. There was bruising that predated your involvement, but there was no evidence that that bruising was anything other than accidental. The conversations in the hospital in which Zoe Coutts said that you really loved Kol are explained by Zoe Coutts seeking to conceal what you had done. Despite that evidence, I am sure that you were also responsible for assaulting Kol in the weeks leading up to his death, causing the bruising that is apparent in the photographs. From the 25th of April 2022, Kol spent many weeks in paediatric intensive care. He was then in hospital for many months. He was looked after by foster parents. His foster mother moved into the hospital to take care of him. She says that he was in great pain and would cry out. It was hard to comfort him, because even cuddling him would cause too much pain. But she was able to placate him, and says that he loved seeing an emotional support dog. Eventually, she was able to take him home where, with the assistance of her husband and professional carers, she provided a loving and caring home. They provided palliative care and appropriate activities for Kol, such as helping to look after guinea pigs. But he remained in great and near constant pain. He suffered day and night terrors. He needed 24-hour care. He died on the 29th of June 2024. His foster mother says that she considers herself to be blessed to have been able to look after him for the time that she did. His death has had a devastating impact on his foster parents and on his father and all who loved him. Scott O'Connor, it's submitted on your behalf that the fatal assault on Kol was the result of a momentary loss of control, meaning that you bore only medium culpability for the offence. The difficulty with that submission is that you maintain that you did not assault Kol. There's no evidential basis for the suggestion that the assault was due to a momentary loss of control. The history of violence towards Kol over a period of weeks suggests otherwise. I'm sure that this was a deliberate, intentional assault. In any event, a loss of control would not significantly reduce the seriousness of this deliberate and violent assault on an innocent and defenceless 2-year-old boy. You bear high culpability for the offence of manslaughter, that is category B of the guideline. You did not intend to cause grievous bodily harm, but you struck a 2-year-old child with sufficient force to tear their internal tissues and cause a catastrophic bleed. There was a high risk of grievous bodily harm, and you must have intended to cause serious harm approaching grievous bodily harm. I reject the prosecution's submission that you have category A culpability, but the case is at the upper end of category B. The guideline starting point for category B is 12 years custody with a range of 8 to 16 years. Given the level of force that was used and the presence of 2 high culpability factors, I adjust that starting point upwards to 14 years. That reflects the seriousness of the offending within the guideline structure before considering aggravating factors. Your offence is aggravated by your history of violence or abuse towards Kol, his vulnerability due to his age, your abuse of the trusted relationship you had with him as his stepfather, your failure to ensure prompt medical treatment, and to explain what had happened to enable clinicians to respond appropriately, and, to a much lesser extent, your previous convictions. The most substantial aggravating feature is the almost constant pain and suffering that was caused to Kol over a period of 2 years and 3 months as a direct result of your assault. The guideline recognises that death involves harm of the utmost seriousness, but in this case the harm is substantially greater still because of that period of suffering. That requires a substantial further upwards adjustment. The combination of those aggravating features is exceptional and is not captured by the category bracket. There is no significant mitigation. I do not accept that the limited evidence of you occasionally showing some affection or care or attention towards Kol reduces the seriousness of the offence. You've shown no remorse, no insight, and no acceptance of responsibility. Having regard to the elevated starting point, the exceptionally serious aggravating features, and the lack of significant mitigation, it would not be in the interests of justice to impose a sentence that is within the category bracket of a high culpability offence. The offence is more serious than that. Manslaughter is a specified offence, and I therefore assess whether you are dangerous. I take account of the fact that you've never been violent towards your own son. I also take account of the length of time for which these proceedings have gone on, and that there's just one incident of violence during that period. I take account of the fact that the probation service have not positively asserted that you are dangerous. But, in the light of the facts of this offence, taken together with the other assaults on Kol, your previous violence, your lack of any remorse or insight, and after taking account of all the matters set out in your pre-sentence report and by counsel in mitigation, I am satisfied that there is a significant risk to members of the public of serious harm by you committing further specified offences. Having regard to the available alternative sentences, I do not consider it necessary or proportionate to impose a life sentence. A determinate custodial term, even a lengthy one, would not adequately protect the public, because the risk you pose arises from enduring features, your repeated violence, your lack of remorse or insight, and your history of domestic abuse. Those factors mean that the risk will persist beyond the custodial term unless it is managed on an extended licence. An extended determinate sentence is therefore necessary in the light of the risk that I have identified. You will be considered for release by the parole board after serving 2/3 of the custodial term that I will impose. If you are released, you will remain on licence until the end of the custodial term, and you will then be subject to an additional extended licence of 5 years. If you are not released at the 2/3 point, you will be released at the end of the custodial term and will then remain on licence for 5 years. If you breach any of your licence conditions, you may be recalled to custody. As to Zoe Coutts, the offence of causing or allowing the death of a child now carries a maximum sentence of life imprisonment, but at the relevant time the maximum sentence was 14 years imprisonment. It's accepted on your behalf that this is a high culpability case. The prosecution go further and submit that you bear very high culpability. I am sure that you disregarded Kol's welfare over a period of weeks, and that you failed to take steps to protect him from your partner, despite the obvious signs of what was happening. These are overlapping high culpability factors. You did not, however, directly inflict the violence yourself, and the period over which you failed to protect Kol was a few weeks, shorter than in some of the other authorities. I conclude that your culpability is high. The starting point is 9 years custody. Having considered how the current guidelines compare with the previous guidelines, and in the light of the fact that the starting point is well within the applicable statutory maximum, I do not consider it necessary to make any adjustment to the starting point in the light of the change to the statutory maximum. Your offence is also made more serious by Kol's prolonged suffering over a period of more than 2 years, and by your deliberate concealment of the offence, by your failure to tell those treating Kol what had been happening. As to mitigation, I take account of all the factors set out in the written and oral submissions advanced on your behalf. You are of good character. I take account of the positive evidence as to your conduct whilst in prison. I also take account of the evidence as to your previous relationship, which made you more vulnerable and may have made it more difficult for you than for others to stand up to your partner. I take those factors into account, but personal difficulties such as these carry limited weight when your young child's safety was jeopardized. You had multiple opportunities to protect him. You chose not to. The aggravating features outweigh the mitigation, requiring an uplift from the category starting point. You spent 511 days on a qualifying curfew. 256 days will count towards your sentence. You will then serve 1/2 of the resulting sentence in custody. After that, you will be released on licence. If you do not comply with the terms of your licence, you may be recalled to custody. I am content that in the light of orders that have been and can be made by the family court and the availability of licence conditions, it's unnecessary to impose any ancillary order in either of your cases. Each of you must pay the statutory victim surcharge in the sum that is required by law. Zoe Coutts, Scott O'Connor, stand up, please. Scott O'Connor, for the offence of Kol's manslaughter, I sentence you to an extended determinate sentence of 23 years imprisonment and a 5-year extended licence. Zoe Coutts, for the offence of causing or allowing Kol's death, I sentence you to 10 years imprisonment, less the 256 days spent on a qualifying curfew. You may be taken from the dock.